Peace, 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 peace. Welcome back to the Universal Temple for the sun, planets, moon, and stars of the Lord of Hosts, Lord Messiah. And we're going back in. You know what I just seen? Plea bargaining was kind of short. I could have fit that into the last video, but it's all good. We're going to start with this one. It's going to be plea bargaining and preliminary hearing. Alright, so let's get it.
Plea bargaining. When the government has a strong case, the government may offer the defendant a plea deal to avoid trial and perhaps reduce his exposure to a more lengthy sentence.
Or when they really don't have something against you, a strong case, they'll try to scare you with a big, sentencing to get you to cop a plea. You know what I'm saying? You also got to be aware of that too. They play games. You know what I'm saying? How they say, hit them high, hit them low. They come at you high, so it, try to see how low you gonna go or how much you can get out of you. So anyway, be aware of that. But basically, but also too, if they do have a strong case against you, they try to offer you a plea bargain. In other words, like if you snitch or cooperate with us, we'll give you less time. This is what they're doing with, like I said, with the Young Thug trial. They're trying to give all these, all the associates, plea bargains so they can snitch on Young Thug and get less time or get no time. You know what I mean? So that's what they're trying to do.
Sentence. A defendant may only plead guilty if they actually committed the crime and admits to doing so in open court before the judge.
Right.
When the defendant...
Right, part of South. So like I said, I think Young Thug, he had him and one of his dudes, whatever, they admitted to the racketeering charge or whatever. And like I said, I think they was facing like 10 years or something, but they got like time served, and I think that's the rest of the time Young Thug gonna do in probation or something like that. So I think I guess he took that plea bargain. But like I said, that's just for what he was charged with that. There's still other shit against him, you know what I'm saying, that they trying to bring through, like I said, getting everybody else to go against him. So when the defendant admits
to the crime, they agree they are guilty, and they agree that they may be sentenced by the judge presiding over the court, the only person authorized to impose a sentence. Sometimes the government will agree, as part of a plea agreement, not to recommend an enhanced sentence, such as additional time in prison for certain reasons, but it is left up to the judge to determine how the defendant will be punished.
Right.
If a defendant pleads guilty, there is no trial, but the next step is to prepare for a sentencing hearing.
Right. So without further ado, let's move to the next one. We're going into preliminary hearing.
Preliminary hearing. Once the defendant has entered a plea of not guilty, a preliminary hearing will often be held. The prosecutor must show that enough evidence exists to charge the defendant. Preliminary hearings are not always required, and the defendant can choose to waive it. It must be held within 14 days of the initial appearance if the defendant is being held in jail. If the defendant is out on bail, it must be scheduled within 21 days of the initial appearance. The preliminary hearing is like a mini-trial. The prosecution will call witnesses and introduce evidence, and the defense can cross-examine witnesses. However, the defense cannot object to using certain evidence, and in fact, evidence is allowed to be presented at a preliminary hearing that could not be shown to a jury at trial. If the judge concludes there is probable cause to believe the crime was committed by the defendant, a trial will soon be scheduled. However, if the judge does not believe the evidence establishes probable cause that the defendant committed the offense, they will dismiss the charges.
Right. So in other words, they gotta have enough evidence to prove you guilty, basically. You know what I'm saying? To prove that you did something. Otherwise, the judge is not gonna entertain it, basically. Alright, so let's go to our pre-trial motion. Alright. Okay, these are not that long, so we can breeze through a few of these. Let's get it.
Pre-trial motions. One of the last steps a prosecutor takes before trial is to respond to or file motions. A motion is an application to the court made by the prosecutor or defense attorney, requesting that the court make a decision on a certain issue before the trial begins.
Pause. So, like I was saying, with Young Thug, when they had illegally seized property from his home through a legal search and seizure, and they try to use that evidence in the trial against him, you know, they try to furthermore put that into evidence and use it against him. One of his lawyers is filing a motion to have that dismissed from the evidence, you know, have it taken out of evidence because, or removed from evidence because it was founded based upon a legal search and seizure, and that violated his constitutional rights. So one of the prosecuting attorneys tried to get up and try to say, well, yeah, but you know, we should still be able to use it because that. He was like, no, well, you know, this unconstitutional rights are violated. That like the judge ain't having that. They about to basically deny that they're going to grant that motion to remove that evidence, remove that those cell phones and all that from evidence, and return him his property, which they've been holding for mad long. So I'm saying, so they won't be able to bring that into evidence and so forth.
Begins. The motion can affect the trial, courtroom, defendants, evidence, or testimony.
Right. So like I said, they won't be able to get up there and say, oh, well, we have this cell phone and we have evidence in the cell phone linking him to something, certain da-da-da-da, because they seized that illegally and they got it through ill-gotten gains, so they won't be able to use that.
Testimony. Only judges decide the outcome of motions. Common pre-trial motions include motion to dismiss, an attempt to get the judge to dismiss a charge or the case. This may be done if there is not enough evidence, if the alleged facts do not amount to a crime. Motion to suppress, an attempt to keep certain statements or evidence from being introduced as evidence.
Right.
For example, if police conducted a search
here we go. Exactly. Let's go.
Search without probable cause, in violation of the Fourth Amendment, it may be possible to suppress the evidence found as a result of that search.
Right. So that was the proper term, the suppression of the evidence. They wanted to suppress the evidence. That was the proper term. Right. So like I was saying, so they illegally searched his home and found whatever they found, and they tried to use that against him as evidence. That was a violation of his Fourth Amendment. You know what I mean? Or of the Fourth Amendment. You know what I'm saying? And it may be possible to suppress the evidence found as a result of that. So due to their illegal search and seizure, he filed a motion to suppress the evidence.
Search. Motion for change of venue may be made for various reasons, including pre-trial publicity. If the local news has covered the case a great deal, it may be necessary to move the trial to another venue to protect the defendant's right to an impartial jury. Step 6. Preliminary hearing. Step 8. Trial. Legal terms glossary. Criminal.
Alright, so let's move to the next one. We're doing good right now. Okay, let's go to trial. Alright, you know, a trial is actually kind of long, so I'm going to save that for the next video, y'all. Alright, so this one was kind of short and under 10 minutes. Alright, y'all, so I'll see y'all in the next one, y'all. We're going to go into the trial after that, after this one right here, y'all. Peace. See y'all in the next one.